Hi, everyone, and welcome to the newest episode of 2030 Vision AI and the Future of Law. I am your co host, Jen Leonard, founder of Creative Lawyers, joined as always, luckily, by the brilliant Bridget McCormick, president and CEO of the American Arbitration Association. Good morning, Bridget.
Good morning, Jen. You look to be in a hotel room by the curtains behind your head. Um,
Yes, this is not my actual bedroom. I'm not this neat and organized. I am in Louisville, Kentucky today, doing a presentation about generative AI, our favorite topic. And it is earlier than normal, so I am caffeinating and might be a little bit quieter than normal or chattier, not sure.
yeah,
But you look like you're at home, which
I
is rare.
am. I did a presentation yesterday about generative AI at New York, and it didn't start until 4:30 or 5 or something. And so I was on the last flight out, and I forgot to tell you this. I Ubered to the wrong airport. I literally thought I was flying out of Newark because I had flown into Newark, but I was flying out of LaGuardia. Like I'm on planes so much that and luckily we had just gotten through the tunnel and the driver said, "What terminal?" And I was like, I said, it's a terminal C. And I was like, Newark, I never at terminal C for Delta for Newark. And finally I was like, oh God, I'm supposed to be at LaGuardia. And I was like, I'm so sorry, sir. Can we turn around and go back through the tunnel and like back to the other side of Manhattan? And I just barely made it. So I'm very happy to be home, but I got home like late and it's early. So we're going to do our best today, but there's lots to talk about as always. Yeah.
There is. And I will just say, we have so many things in common, including that I have done that before. I did this
None.
last summer. I was in Florida and I just assumed I was flying home out of the Miami
Oh,
International Airport. So that's where I went. And I insisted to the person at the American Airlines counter that I was in the right place. And she very rightly insisted I should have been in West Palm Beach. So then I took the scariest, fastest Uber ride of my life from Miami to West Palm Beach. So I have done that before. Um, it is a terrifying feeling, but well, I'm glad you are home in Michigan, and it's lovely to see you. And today we are going to talk about deep research, something that you and I are using, and through OpenAI, specifically their new deep research product. Google helpfully has a product with the exact same name, Deep Research, in the ongoing terrible naming conventions and trolling that happens across these tech companies. So we're going to talk about that. But before we dive into that, we will do our regular segments, which are our AI aha segments with again, gratitude to Megan McMillan at Cleary for naming our segment. The moments that we find that are delightful about using AI. And then we'll move into our new segment, which is our What Just Happened segment of catching people up on a couple big pieces of AI news, and then we'll dive into our main topic for today on deep research. So, what is your AI aha moment for this episode, Bridget?
I had a hard time choosing one this week because I've had a few different ones, really different ones. But I'm gonna tell you about a panel I was on last Friday at a construction conference, a conference of very senior construction lawyers and arbitrators. And the three other panelists were lawyers and arbitrators. They kind of pulled me in because the panel was about AI, and and they did a pretty interesting thing. They took a mock construction dispute file that they had put together for like a law school exercise, and fed it into just the free version of ChatGPT. And then they did all in advance of the conference. And then they asked everybody who was coming to the conference to answer the same 8 questions that they asked the free version of ChatGPT to answer. And then they did sort of a comparison of where the free version of ChatGPT kind of got it right. Because it basically like went right to the final use case in dispute resolution and said, decide this dispute, free ChatGPT and let's see how you do. And it was like shockingly good. Like just the free version, I think their data showed it agreed with these like senior experts in the field in 6 out of 8 of the specific questions they asked it to decide. And on the other two, they were the ones that they really were nuanced, and the group was kind of divided. And so it reminded me of Adam Unikowski's experiments with the Supreme Court decisions on the case on the questions that were close. It didn't come out the way a majority of the participants did, but it was everybody kind of agreed, like, that was debatable. And when I first saw the, results of the experiment, I asked the other panelists, I'm like, "Shouldn't we try and run this through the paid models and some of the reasoning models because we're probably gonna get different results?" And they ended up running it at least through Claude 3 Sonnet. But I think I was wrong because by doing it in the free model and showing just how good it was, this entire room of senior lawyers, many of whom hadn't really been using it regularly yet, were I think we're pretty moved by the fact that just the free version could do such a good job. Um, so I always tell people who are using the free version that you have to use the paid version, and literally since then, I've now been telling people, or just use the free version. Like, I mean, it is stunning what even the free version can do, and I do think until you just use the technology, it's hard to really appreciate how impactful it's going to be and what how it's a general purpose technology that's going to change our lives. So the aha was not like the technology doing something delightfully new for me that I hadn't, but just sort of the Back to the Future that the basic model can really, uh, open eyes in a way that's stunning. So, I don't know, maybe that's not aha enough, but it was stunning, I thought. Yeah.
Well, I think it's sort of like 2 levels of aha, right? Like, you're identifying 2 different ways to use it in that context. One is for demonstrative purposes, just helping people see how powerful it can be, and for that purpose, it sounds like the free version has the free version improved enough over time from, user engagement? Because it definitely was not there a couple years ago.
Yeah. No, that's right. I it must have improved, I think, significantly because it really was the outputs were impressive. So and it makes sense that it's improved. I don't ever use the free model anymore, so I'm not in touch with that, but, um, it was pretty impressive what it did. I thought impressive that they did it, that they, ran this experiment, and
That's
showed the
very cool.
results. Yeah, yeah.
But the second level, I guess, to your other question is if you were actually going to deploy it in a real world context, you could use the deeper, advanced reasoning models and get better results probably.
Yeah, and I that was kind of my value add on the panel was to explain to everybody what the reasoning models do differently and how, um, if you thought this was impressive, get a subscription and run it through the reasoning models and see what happens next, and it was a really interesting conversation and real a lot of openness. I'm seeing more and more openness from lawyers, or some, I should say. At least the construction bar. The construction bar turns out to be, like, pretty at the front end of a lot of, technology changes. I think because there's so much technology in the underlying business that they're involved in. So the bar seems to be, curious, you know, interested, which is fun. Yeah. How about you? Did you have a AI moment this week?
So, well, first of all, we did not catch up on football news. My birds won the Super Bowl, and I will say I used AI to develop a menu for our neighborhood brunch that we hosted, which is not an AI aha, but it was an aha in the sense that I decided to host this brunch for 25 people and all their kids like the night before, and then use ChatGPT to create French toast sticks and egg casseroles and all of these things that were really easy to make. And we've talked about that before, but that was delightful. I just said that to say go birds. But my AI aha, thank you. My AI aha was more of just this realization that I feel like I have crossed a threshold personally with my engagement of AI that I feel increasingly that I live in a different world than people who are not using this technology regularly. And it's a weird feeling because the faster the technology moves and the more I use it, the more I feel like I literally live in the future. And I talk to lots of people in my life who are very thoughtful, including about these topics. And when I probe, whether they're actually using the technology or how they're using it, they're not really using it at all. They're interested in it, some people. But when I say, are you using O1 or O3? Have you tried, the new reasoning models? They're not even off of the free version of ChatGPT. And I had a conversation a few weeks ago with someone at lunch in a totally different industry, and their industry is like square one, like, we just want some information about this. And I don't know, I don't do anything now without thinking first, how can AI help me do this smarter, better, faster? And so I don't know. I don't know if you've had this experience. It just feels like everybody else is 30 years behind now,
Yeah.
and that's weird.
Yeah, it is this, like, liminal period is it feels weird because I don't know if we were having this conversation 2 years from now, I bet it will then be if it's once it's in all of our iPhones and in all of our appliances, and again, the robots are bringing me my coffee or Diet Coke or wine. Um, we'll be through it, but right now we're in the middle of it, and it is odd. Yeah, it's really odd. I feel the same way. I don't yesterday, w our chief people officer at the AAA was describing to our board our promotion rate, and one of the board members asked a question that I had never thought to ask, which was, "What's a healthy promotion rate? Like, what where do you want it to be? Like, what's the" and, he had great answers because this is what he does for a living, but I didn't, so I read immediately, like, to my friend, uh, ChatGPT, and got such a, like, thoughtful answer, and, it was I wouldn't have in a million years, I wouldn't have gone to Google and just wanted to get a bunch of links and, like, look through links to find, like, what different people say about the answer, like, I wanted it synthesized and organized and, so, yeah, it is interesting. Yeah.
So weird. And we could talk on future episodes too about how this will unfold in education too, and how students increasingly I just don't think they will come to classrooms without having engaged with AI in some way. Um, and there's a study out, I think last week, a new survey of employees across different industries that I think 30% of people are actively using AI at work now for professional purposes, whether they're allowed or not.
Yeah, exactly. I heard that somewhere. I don't know, one of our podcasts that we always listen to, but I forget where, and I couldn't tell how many of the in the 30% were secret cyborgs or were just allowed to use it. It wasn't clear to me. I don't know if you know, but
I don't know, the answer to that, but I will say I am sort of hearing more conversations in our industry about secret cyborgs as a major problem, um, in organizations with people finding out, that people are using tech for all sorts of things. And I just think that is the future, right? Um, so very interesting. So we could talk in future episodes about all of that. But we'll dive into our What Just Happened segment because AI moves so quickly and people are probably seeing headlines float across their transoms and not having time to focus on whether it matters or not. So maybe you can kick us off. We have two What Just Happens this week. The first is Elon Musk made a bid, an unsolicited bid, that maybe you can tell us about to buy OpenAI.
yeah. So, maybe this was last week. I don't know. Like you said, everything moves so quickly, but Elon Musk and a group of other investors made an offer. Again, as you said, unsolicited, to buy OpenAI for $97.4 billion. And like, you know, a as you do when you're offering to buy a business for $97.4 billion, I think he made the offer on X, Twitter, or maybe not. Maybe he also made it in real life, IRL. But he but it played out on Twitter because and I'll in a minute, I'll talk a little bit about OpenAI's current structure and, how they're trying to transfer it. But Sam Altman right away, tweeted back at him and said, "No thanks," or, like, "Not interested, but I'll buy Twitter for $9.7 billion." And Elon Musk tweeted right back at him with one word. I think he said swindler. So it was like another, little public, back and forth between Elon Musk and Sam Altman. And then the OpenAI board officially turned down the bid to purchase OpenAI for $97.4 billion. But correct me if I get this wrong, but so OpenAI was founded as a nonprofit, and its mission is to bring artificial general intelligence to the world. And if that's your mission, you succeed whether you OpenAI are the ones that bring it to the world, or your work plants 1,000 other startups, and one of them brings it to the world, right? That's the thing about a nonprofit mission driven organization. It's not really, doesn't have to be us. It's just that's what we're working towards. And then in 2018 or 19, they stood up within the nonprofit governance structure a public benefit company. Is that the right term? Is that the right for-profit term? Public benefit
PBC?
company? Yeah,
Yeah, I think so.
I think that's right. And so they have a for-profit, obviously, so they could raise funds, which they've obviously been doing with stunning success since then, because they've raised um, billions of dollars, right? Since they stood up that for-profit subsidiary, and now they're trying to change their nonprofit business, which is the parent business of the
The
for-profit,
for-profit.
yeah, into a fully for-profit company. And there's a process for doing that, and you need regulatory sign off. And some commentators viewed the Musk uh, unsolicited bid as just an attempt to complicate that. It is also the case that Musk and, well, maybe it's just Musk, has sued OpenAI to stop it from transferring to a for-profit business. And some commentators view this bid as just like another arrow in the quiver of slowing OpenAI down and stopping their ability to transfer to a for-profit company. I don't really know, and so we shouldn't get into like the legal framework for changing your nonprofit business to a for-profit business. Please go to an actual lawyer who knows something about that. Don't come to this podcast for that. But but I but I know that a nonprofit has to act in the interests of the public it serves. And if you get an offer for $97.4 billion, I think it's fair to say that you're supposed to actually think that through and consider whether you have to accept that offer, because it's in the interest of the public mission that you serve, over your alternative path of changing into a for-profit company. So I don't know. At the same time, this week, Elon Musk, his AI company XAI released its latest model, Grok Grok 3. I guess it's 3, yeah. And it's a reasoning model. It's a multimodal model. By all accounts, I haven't used it myself, so this is not from personal experience. But by all accounts, it's a pretty sophisticated model. Um, and one of the pitches Grok 3 is making is that it can revolutionize law and justice. It said they literally say, like, send your disputes to Grok 3 and we can resolve them quickly and efficiently and inexpensively. So it's a funny sort of combination of what just happened moments. Both Elon Musk's own company seems to be uh, targeting legal, and it has legal in its sights. And at the same time, Musk is, you know, has a pretty sophisticated legal strategy to slow OpenAI down. And I think this was the latest piece of that strategy. I don't know. Did you pick up anything else on the back and forth that's relevant?
No, I mean, I think for lawyers, what a lot of lawyers may not realize is A, that Elon Musk was a co-founder with Sam Altman of OpenAI. And at one point before he was sort of ousted, from the board and or by the board, he wanted to convert OpenAI into a for-profit
Yeah,
company,
that's right.
and tie it to Tesla. And that was in point of tension between Elon and Sam at the time. So it's all just like part of this messy soap opera that is OpenAI and Sam Altman and Elon Musk. But I think you're right. And I think this will not be the last time that Elon tries to slow down his competition using the law to try to complicate things. But they're also, as you said, I mean, they have created this complicated legal situation for themselves in the first place through the creation of this very complicated nonprofit overseeing a for-profit structure.
Yeah, the other thing that happened this week, and maybe you can tell us about this, is there was what most people are saying is a pretty significant sort of first decision in AI training, sort of training data issues and copyright, and that was the Thomson Reuters versus Ross AI decision. And you and I have talked about it briefly, and I know you've actually read the opinion by uh, Third Circuit Judge Bibas, who was sitting as a district court judge, and you and I both know Judge Bibas, and so it was kind of fun to follow this opinion. But you want to give us like the high level again? This is not a podcast you come to for understanding doctrine. That's not what we're doing here. We're talking about change management for lawyers, not legal doctrine. But this is kind of relevant to the whole story for lawyers. So tell us a little bit about Thomson Reuters versus Ross AI.
Yeah, so this was a case that was originally filed in 2020, and as you mentioned, Judge Bevis is sitting by designation in the District of Delaware, which when I read the headlines and they started coming across, my law.com feeds, I didn't actually even realize because Judge Bevis normally sits on the Third Circuit. But this is at the trial court level, and this ruling was significant because he ruled in favor of Thomson Reuters on a summary judgment motion that he actually welcomed the parties to file and brief because he had earlier sort of ruled in a different way. So we both loved the opening at the very beginning. Judge Bibas says, quote, "A smart man knows when he is right. A wise man knows when he is wrong. Wisdom does not always find me, so I try to embrace it when it does, even if it comes late, as it did here." And you had remarked, Bridget, as a former judge yourself, how rare that is.
It's really hard for judges to admit when they've gotten something wrong, but I always feel strongly that it really actually grows public confidence in the judiciary when judges can say, like, "I'm human and I got this wrong, and here I'm gonna do better." And so I'm sorry I keep saying Bibas. I get Judge Bibas's name wrong, or is it Bibas? I'm saying Bibas and it is Bibas, right? It's Bibas, yeah. Sorry.
Judge Bibas.
It's
And
Bibas.
the only reason I know is because he has been on the faculty at the law
Right.
school where we have both taught.
Yeah. Yeah,
Um,
yeah, yeah.
so
No, and he and I actually were both new to the ALI council, so we both gave our, like, introductory council speeches a couple weeks ago. So I was just with him a couple weeks ago, so I should start getting his name right because I really like him. But yeah, I loved this opening. I loved, like, being, like, right up front with, "I think I got this wrong before, and so I'm trying again." It's the humility. I mean, humility is a pretty important quality in a judge, and this was a great example of it. But back to the case, or
definitely. And if you are interested in copyright issues and doing a deeper dive, the opinion is definitely worth reading. And it's stunning the amount of diligence that Judge Bibas and I'm sure his clerks did in reviewing thousands and thousands of Westlaw head notes and comparing them with these briefs, these sort of big briefing documents, briefing memos that Ross had created in making what it tried to make, which is at the heart of this case. So the upshot is that Judge Bibas really got to the heart of fair use in this case, which was a defense that Ross had raised. And he has another great quote from the opinion where he says, quote, "None of Ross's possible defenses hold water. I reject them all." And this included knocking out Ross's fair use claim, as well as some other claims that we won't get into. But the important part was when he walked through the four-pronged test for fair use, and he really focused on factor one, which is the purpose and character of the usage, and found that Ross's use was commercial, trying to sell a product to lawyers for legal research, and importantly, non-transformative. So that they were taking Westlaw head notes and using them to train an AI model. It was not a generative AI model, which we'll get into in a minute, to produce a product that it would sell to the same exact market that Westlaw serves, which are lawyers and judges. So that was factor one in favor of Thomson Reuters. And then factor four, which the opinion explains is the most heavily weighted factor in fair use cases, is the market effect. And it weighed heavily against fair use here. The product that Ross was developing was intended as an actual replacement and competitor to Westlaw. So it implicated Westlaw's primary market, which was legal research services, but he also noted that there's this new emerging market for licensing data for AI training. And so that's a market that Thomson Reuters would in general develop or license others to develop. And that market came into play in the analysis as well, which was really interesting. So those are sort of my big takeaways from the case in terms of the substantive law.
Yeah, and just to take a step back, just to so Ross was a startup that was, it was building a tech product that was a legal research product, right? Like, that's what Ross is, by the way, out of business, went out of business because of this litigation, I think, at least that's what I read. So they're no longer in the market. But I believe that's what their product was, right? It was just gonna be a legal research product, that therefore was a pretty direct competitor with TR. And the copyrighted piece of I'm sorry, the copyrighted piece of the TR product was the head notes, right? Because this is the important distinction. The legal opinions themselves, when a court issues a legal opinion, that's not copyrightable, right? Like, you can't copyright that. Wes can't just say, like, "We grabbed it, so, we own it now." The law is actually, a public good, and so you can't copyright that. But as all of us know who went to law school and, practice law, the the head notes, are what West has, added to the law that is the protected product, right? And that was the question here was are the head notes that West has added to, the public good of law copyrightable? I think that's right.
That's right. And the creative element is the numerical taxonomy that you reference that lawyers use to really develop connections across case law, across treatises. Any lawyer who's ever lawyered, right, knows how to use Westlaw headnotes and keynotes to find nuance and add value in that way.
So does it do, so that yeah, you see all this like back and forth commentary or across media after this opinion about what it means for the frontier model companies that, as we know, are being sued by many other businesses because they believe that their data was used to train those frontier models, right? The New York Times, I think, is the lead plaintiff in one of the biggest cases against OpenAI in particular, um, for violation of copyright. It do do you think that, Judge Bibas's opinion, predicts an outcome for all of those pending, lawsuits? And I know we're not gonna make legal predictions about how doctrine goes here exactly, but, like, how far does this opinion go? Like, what does it tell us about that litigation that's coming down the line?
I think it will obviously be used by lawyers, both as persuasive authority if you would like your cases to come out in the same way, and if you don't, distinguishing the facts in your case from the facts here. But it's a district court case. It has no precedential value outside the District of Delaware, and so the real question will be what will appellate circuit courts do? And if there eventually are splits across the circuits, what will the Supreme Court do if it takes a case like this? And that would really change the landscape nationally. But is that how you're thinking about it? I think outside of legal circles, there's sort of an overstatement about the import of this case in the broader tech landscape and how precedential it is.
Yeah. Judge Bibas was careful to note that this was a pre-generative AI case, that the what Ross was doing was before um, generative AI, and it's just like traditional AI, and that might make a difference. I mean, there are some other things that might make a difference as well, but frontier models that may or may not have trained on um, Westlaw's products might have some different defenses that they raise, it seems to me. I mean, I don't know exactly how all of those will play out, but I can imagine how they would differentiate their their process from the process that Ross used and their use case, right? Like the frontier models were not. I have no idea if they trained on West products. Let me be very clear. No idea what they trained on at all. I don't think anybody knows right now, right? That's like maybe we'll find out in some of the litigation that's pending. But if they did train on Lexus or Westlaw's um, products, I could imagine them saying, "But we weren't doing that to build a competitor uh, for Lexus or Westlaw. We're just trying to train general purpose technology, right? We're building the printing press, the steam engine. We don't really care about competing with Westlaw, and we don't intend to compete with Westlaw. Although Grok 3 apparently does, because according to its announcement last week, it is ready to go and going to be faster and cheaper than um, uh, traditional legal services. So I don't know. I think it'll be interesting. I think we don't yet know how it's all going to play out. But it was interesting that Judge Beavis was really careful to make the to draw that sort of line around what he was doing and what he was not doing in this particular case.
Yeah, and there were several points where he was really clear about the nature of this case, the generative AI versus AI point as you made, and then the direct nature of the competition between the two parties here. And I think you're absolutely right that it gets a little bit more complicated when you're talking about a general purpose technology that will be used in lots of different ways, and it seems like even the tech companies themselves don't know exactly which markets they're trying to serve, which is their big challenge at the moment. Um, but it also, it's interesting in terms of what it means for startups, and we talked about DeepSeek and, how that caused heads to spin in Silicon Valley around whether you need all of the resources that they're trying to gather, to be competitive. But as you mentioned, in this case, Ross literally went out of business because of this lawsuit. And so it does create a roadmap, I think, for big tech, if they are able to find sympathetic judges who agree with Judge Beavis's reasoning
Yeah,
here to stifle innovation. And so that, to me, I mean, it's like, the inherent tension between protecting original works and promoting innovation.
yeah. In the legal context, it'll be interesting, right? You know, because the underlying law is not copyrightable, it is sometimes hard to find. It's not if you just want to like go find every contract case that the you name the Texas Supreme Court has issued. The easiest place to go get it is Westlaw or Lexis, because they've already gathered it, organized it, made it at least possible for lawyers to kind of sift through. Um, but it's not the only way, right? So the frontier model companies, theoretically, maybe Grok 3 already did this, could go to every single state and ingest all of the legal doctrine that's come out of all of the courts in those states. Again, state court can be tricky in a non-unified state court system. You might literally have to go, across the state, district to district, to get every trial court's opinions. But it certainly could be done if you have the resources. And I think the big frontier model companies have the resources, right? So, assuming they can ingest all of the law without the wrappers that TR and Lexis have put on them, they could organize it in a brand new way, right? I mean, couldn't you imagine? And maybe now we're like starting to shift into our main topic, which is OpenAI's deep research product, which you and I both broke down and purchased the pro model so we could start using it, and we don't regret it because it's amazing. But can't you imagine once they've ingested all of the law, you know, that they could organize it in, a brand new way? Like we lawyers have accepted, the version that we've been given by a couple of companies. We could imagine. My guess is these frontier model companies could probably produce some new ways to organize doctrine.
Absolutely, and, that's why when I was reading the opinion and some of the commentary around it, it already feels, and this sort of goes to the AI aha moment from earlier, courts move slowly, legislation moves slowly. This case was filed in 2020. It's now 5 years later, and we're getting a decision on a summary judgment motion. Um, it made me think about the early days of the massive change that happened in the music industry, and when Napster came out and, the walls at that point were sort of holding for a while, in favor of the incumbents, and eventually technology, innovation, market demands, consumer preferences really led to the complete deterioration in a lot of ways of the major record labels. And so, to me, if I were an executive at Thomson Reuters or one of these large companies that is an incumbent, I don't take that much solace in in this ruling. It's a good, maybe, like, temporary win. But like you said, all of these big tech companies are sucking up as much information as they can. The underlying information here, you and I have talked about this in presentations all the time. It's both some of the most trustworthy, well edited, well written source material on earth. And in the public domain, the case law is not copyrightable. So we'll talk about this in the main topic, as you said, so we can move in that direction. But once that data is available to these companies, I think we're in a new era in terms of how we engage with legal, information and how people understand the law. Before we do that, there's one super minor point that kind of relates to our main topic. We have both purchased the deep research subscription from OpenAI. I don't regret it for a minute, even though it's $200 a month, which seems like a wild amount to pay. It's amazing, the kinds of research that it can do and how helpful it is in a million different ways. But I used it to prep for our podcast today to learn more about Judge Bibas's opinion, and it was a minor thing that I noticed that in the generated, research report I got, it continually referenced, public-facing thought leadership from Davis Wright Tremaine and Skadden, and I think for law firms, this is the direction they need to be heading from a marketing and business development standpoint, because if I'm a party potentially who's concerned about these issues, I'm now picking up the phone and calling Skadden or Davis Wright Tremaine to help me navigate all of this. So we really, and Ethan Mollick talks about this, moving from this SEO world to an AI optimization world. And it feels to me like an easy win for law firms to be getting more and more of their thought leadership out there so that it does get sucked into these deep research tools.
Yeah, it's an interesting that is interesting that those 2 firms came up. I mean, I actually haven't really followed either of them in their AI space, but, they obviously are thinking about it, I think, if they're finding their way into the deep research outputs, right? Like, they yeah.
Yeah, and it looked like, at least in the case of Skadden, I've done panels with, representatives from Davis Wright Tremaine, so I know that they are being really intentional about this. Skadden, I don't know intimately, but I did notice that the resource that they were citing in the report is some sort of Skadden AI thought leadership that is directly, AI related. So the whoever is thinking about their external marketing and how AI is capturing it is really being explicit that scans focused on AI. Um, but all of that leads us to our main topic, which is deep research. We've been using it. For those who haven't used it, deep research is a new tool and application available through OpenAI that does exactly what the name says, which is refreshing from OpenAI, which is not historically great at naming things. But deep research will take your prompt. You can ask, as we did for this, tell us about the opinion in Thomson Reuters v. Ross. It will then respond to you with a series of questions that you would get from a very smart junior associate, I imagine. Do you want me to look in the legal industry only, the tech industry, both? Are you looking for thought leaders' responses or only other courts? It asks you a whole bunch of questions, you give it the answers to those, and then it goes off for a few minutes and does deep research and presents you with, a report that is not just a summary, which is more like Google's deep research, option, but really goes deeper into what the implications are, where the nuanced perspectives are, and I just find it to be absolutely amazing.
Yeah, it's a stunning product. I mean, I like you, I don't regret it at all. It's just, it's really pretty incredible to have that kind of help right at your fingertips, and, it's very smart, it's very thorough, it's very efficient, and it does feel like the next step in forcing lawyers and legal businesses to think differently about how their work is valuable, which, like, I absolutely believe it is. I believe that, the human piece of what we do is critical. But if and I think you and I were in the same conversation with a partner at a big law firm, we don't need to be specific, who used it and produced a pretty, I think he said, A minus level brief. So if you can produce A minus level work in minutes, rather than what might take an associate a week, 2 weeks, we're just gonna have to think differently about what practicing law means, right? I or we can get, excited about what it means, right? Because it can allow we can probably do a whole lot more, and a whole lot more of what we like doing. But it definitely feels to me like the next, reminder to lawyers that you really gotta get serious about what this means for what we do. I don't know. Other takeaways that you have?
And we talked about this. When I ran the deep research report on the Judge Bibas opinion, my first thought was if I had gone back to the days when I was a junior associate in a law firm and a partner had asked me to pull that opinion, read it, interpret it, figure out what the implications were for our clients, and not bill too much time to it, I remember those days. I remember being brand new to understanding anything about the law and just trying to figure out, like, how to read things well and capture all the nuance, and this produced a result that I could never have produced as a junior associate, and even if I could, it would have taken me, I think, like, weeks to come up with something like this of billable time. So, for the business model, I just think that we are not that far away, as you said, and we'll talk, now, I guess, about the paywall issue. Once that unlock happens, and I think it will happen because of the reasons that we talked about earlier, that it's not copyrightable information, it just requires somebody to gather it. Um, we're in a totally different world then.
Yeah. The paywall so, yeah, I have so many different thoughts, like, intersecting. The paywall has been what everyone has thought was maybe the barrier to, this technology having a fast impact within legal, but I'm not confident it's hasn't already been, overcome. Like, I mean, we don't know, 'cause it's not like these private companies have to report what they've scraped or where they've gone and, ingested data. And again, let's be very clear, you're not doing anything wrong to go ingest every legal opinion, and as it should be, frankly, right? The law should be free and public. It should also, frankly, be understandable to people who are governed by it, but that's that might be asking for a lot. But it's not maybe the frontier model companies have already ingested all of the law and the paywall, um, if you experiment with deep research and ask it legal questions, you might come to that conclusion. I have to say, I don't know, but if you see the results, you might think it has. So the paywalls, I think, are not long serving as moats, in the legal industry or any other industry. My Zach Abramowitz, who I do another podcast with, he calls you his podcaster-in-law. You guys are like you're his podcaster-in-law. He said everything is it's pace of innovation over moats with this technology. Moats are useless. Like, and paywalls are moats and they're useless. It's pace of innovation over moats. And I think he's right about that. And this
Or as Ethan Mollick says, speed is a moat,
yeah,
which is the same
same
point.
same idea, I think. Right. Yeah. Yeah, I don't know. I mean, when Ethan Malik was the one who first started saying, like, assume paywalls are not an issue, right? In 5 minutes, and it might be 5 minutes ago at this point. Like, I don't know where we are on whether paywalls are doing anything anymore. What's your thought about that?
Well, maybe this is a helpful comparison because when I was running the deep um, research for this podcast, I went back and forth with the model and asked it to pull the actual opinion, which again, problematic for Google because before I would have gone to Google to find it. And it immediately produced a PDF I'm sorry, it produced the link to the District of Delaware's website where I was able to just easily click on a PDF, which I then took and uploaded to Google Notebook LM and turned it into a podcast to listen to. um, but I think to your point, the challenge really has been before, as you talk about frequently, scraping state court data, getting all of this really disconnected information in one place. But because it's out there publicly and it's not copyrightable, the model will go get it for me if I ask, which means it has access to anywhere on the web where this information is publicly available. Um, by comparison, I'm working on a different project where we were trying to get articles from inside higher ed, like the paywalled, publication for higher ed administration. And I ran a deep research report on what they've written about last year on generative AI and higher education, and it produced like a summary of 20 different articles. And then I asked it, "Well, isn't this a paywalled resource? How are you able to actually give me summaries of these? Because I don't have a subscription to it, and I don't know that you do either." And it said, like, "I cannot access the underlying information beyond the 5 free articles that you get. So I'm basing the summaries on other public commentary about the underlying articles." Um, so I think the point that you're making is the really important one for lawyers. Like, our information really isn't behind a paywall. The way I had been thinking about a paywall was the paywall we use to access Westlaw and Lexis. But the Bebas opinion and our knowledge is that the underlying information is not paywalled at all. It's not copyrightable at all. So I think it's a bigger opportunity and challenge in legal for that reason.
Yeah. And the product obviously wasn't, OpenAI didn't say we're releasing deep research, which is basically, an associate at a law firm, because in fact, it's also, a consultant at a consulting firm and whatever the field is, it works as basically a junior partner in that field. But it really is, I know legal work because that's what I've spent my life doing, and the things that it does, like you said, are so similar to what you might ask an associate to do, researching and making connections across different sources of law, and synthesizing the places where there's a conflict, or not. It feels like it's just doing the kind of work that you need lawyers to do, right? So, I don't know. I mean, it does remind me a little bit of the JAMA study that we talked about. I don't know, now it feels like, 18 years ago, but it was probably in December. Um, but, again, interesting that medical researchers are, like, willing to disrupt themselves this way, right? They do a study and show that that the frontier models can do better diagnostic work than human doctors, and in fact can do better diagnostic work than human doctors using the generative models, and that's because the human doctors always override the generative models' suggestions. Um, it feels like that kind of moment for lawyers. Like if we can see now that this is going to do a lot of the things that we thought we were meant to be doing, um, let's see the upside potential of how we now can have this fully fully available partner to do some of the tedious things that have to be done to be able to exercise the judgment and help people solve problems in a way I still think humans can do better than better than technology. But but I don't know. It does feel it feels very similar to me than to that JAMA moment. Like oh,
Yeah.
we're gonna have to focus on the things that we really do well. Yeah.
Yeah, and, maybe we'll just close, and I'll just say my final thought is, and we do these presentations together separately, to law firm leaders about what makes this technology so different, and so many lawyers compare it to when we went from book research to online research, or we went from handwritten memos to emails. I think that is a helpful framing to know that we can adapt and we can change, but to your point, it's not helpful in understanding the nature of what this technology is and what it means for lawyers because it's not making digital or automating things that we used to do in an analog world. It is actually doing the things that we bring value to currently. Um, so that's my final thought. Anything to wrap us up today, Bridget?
I still think that it still makes me optimistic because again, I mean, I don't know, maybe some people loved that kind of work, that kind of digging through and making sense of um, you know, legal different legal sources and organizing it. But I love the idea of just having a super available, never tired, never hungry, partner to do that part and then be able to then think strategically and creatively with a client about what choices are that the client could make. So I going to still end with optimism because that's how I feel. I think it not only will allow you to do the things that you're uniquely poised to do, but also do more of them. Right? We can get more legal services to more people, which again is a huge upside. So
Yeah.
ending on my
Yeah.
positive note.
Same. And it made me feel positive as well. Also, a little bit more about legal education, having this opportunity to sort of visit a legal issue using deep research. I've been really, really troubled around what this means for learning. But I think there are really interesting ways that we'll be able to use these tools and have students learn through the opinions because reading the opinion was still very different and important as compared with the deep research. Um, so maybe I feel less alarmed than I did, but also more motivated to help people who want to think differently about how we transition into that future. So, such a great conversation. As always, we did not stick to our like 30-minute goal, but hopefully it was helpful. I am tired and hungry. So I'm sorry that you need to engage with me for some purpose. So I'm going to go find some food. But it was so great to see you.
You too. Good luck on your presentation today and have a great weekend.
You too. And thanks to everybody out there for listening. We will see you next time on 2030 Vision, AI, and the Future of Law. Thank you for tuning in to 2030 Vision, AI, and the Future of Law. If you enjoyed this episode, please subscribe to our podcast and leave a review. Stay informed and inspired as we continue to explore the AI-driven future of the legal profession. We'll see you next time.